Vacating the denial of a motion to suppress breath test results and remanding for the trial court to determine whether the state had carried its burden of showing that the defendant had voluntarily consented to the breath test. Never volunteer. Never. You say, I am not taking any tests. I'm exercising my Fifth Amendment right and my right to remain silent. You give them your driver's license, your registration, your insurance if they ask for it. That's it. Other than that, you say nothing. Not a damn thing. You don't even say hello. They'll ask you questions like, where are you coming from? I don't answer questions. Where are you going? I don't answer questions. Tell them you want a lawyer present before you answer any questions. They'll probably tell you, well, we can't bring a lawyer here and you're not under arrest, so what? Thus, as made clear in Olivec, the Georgia constitutional right against compelled self-incrimination requires a trial court to grant a motion to suppress incriminating results from a state-administered chemical test unless the state proves that 1. The defendant was not required to perform an act to generate the test sample, or 2. The defendant was not compelled to submit to the test. And by what they mean compelled, that you weren't forced, you have to volunteer. Never volunteer. Even searching your car. You may not have anything in your car that would incriminate you, get you charged with another crime. Still, can we search your car? No. If they say, well, we'll get a dog here to sniff, do what you gotta do. And what they do is, they'll take that dog, they'll give it a command, and they'll say it hit on something, even though you have nothing in your car, just so they can search. And I would challenge that in court every time, and I would sue them. Under Elliott, whether paragraph 16 requires a court to grant a motion to suppress a defendant's refusal to submit to a state-administered chemical test turns on whether the defendant would have been required to perform an act to generate the test sample. They're going to use the implied consent law. It's no good. Unless the state proves that submitting to the state-administered chemical test would have required the defendant to perform an act to generate the test sample, paragraph 16 requires a court to grant a motion to suppress evidence that the defendant refused to submit to the test. So even if you refuse, they can't hold it against you. They can't use it in court. And that's it. They really have no evidence against you, except your own words. So don't say anything. Under Olivec and Elliott, the right against compelled self-incrimination protected by paragraph 16 prohibits the state from admitting into evidence a defendant's refusal to submit to a urine test, when doing so would require a defendant to urinate into a collection container to generate a sample for chemical testing. This collection method necessarily requires a defendant to cooperate with the state by performing an act that generates self-incriminating evidence. Specifically, a defendant must urinate into a container at the time and in the manner directed by the state to ensure that the state can obtain a usable test sample for chemical analysis. Although urination, like breathing, is a natural bodily function, the state is not merely collecting urine expelled in a natural manner when it asks a defendant to produce an adequate amount of urine in a collection container at a specific time. Instead, the state is asking the defendant to affirmatively give the state evidence from the defendant's body in a particular manner that is neither natural nor automatic. Accordingly, under Olivec and Elliott, paragraph 16 affords a defendant a right to refuse to submit to such a test and the right to suppress evidence of the defendant's refusal. Awad had a right to refuse the state's request that he provide a urine sample in a collection container. The trial court properly granted his motion to suppress evidence of his refusal to submit to the test. Challenging this conclusion, the state argues that our decision in Green v. State, a case involving a probationer, established that the state's obtaining a urine sample does not implicate the right against compelled self-incrimination because providing a urine sample does not require an act on the part of the defendant. Now, let me just say something right here. They're using Green v. State, the state is, involving a probationer. There's a difference when you're on probation. You sign a document that says you will cooperate and do these things, okay? That's why you're on probation. But here, Awad isn't on probation, so he doesn't have to agree to anything. And in this case, the Georgia Supreme Court says, in Green, we rejected the probationer's argument that the state's use of his urine sample as evidence against him had violated his paragraph 16 right against compelled self-incrimination. We noted that the probationer had been required to provide a urine sample as a condition of his probation and quoted that condition as stating that the probationer shall, from time to time upon oral or written request by any state law enforcement officer, produce a urine specimen for chemical analysis. That is the difference. So, refuse, refuse, refuse. Refuse anything. And they're going to say, we're going to take you to jail if you refuse. They're going to take you to jail anyway, even if you agree. They're not just going to let you go and say, oh, now that you gave us the urine sample, we're going to let you go. Goodbye. No, they're going to test that sample, and if it's at 0.08 or above, you're arrested. So let them arrest you anyway. Refuse, arrest, and let them arrest you. You're going to get out quicker. It's going to cost you practically nothing, okay? Yeah, you may have to post a bond to get out, okay? But you'll get that bond back because the state won't even be able to take it to court because they have no evidence that you were impaired in any way except the officer's testimony, and we know how good that is, okay? They lie up the ass, so don't even worry about it. I mean, here in Georgia, in Statham, a cop in Statham was arresting sober drivers for DUI. They were stone cold sober. Can you believe that? And he was still arresting them for DUI. So, you know, they're going to do what they do. So refuse, refuse, refuse. That's all I can say. Refuse, exercise your right. You have to exercise your right. Tell them that you are exercising your right to remain silent. You are refusing any tests of any kind. Field sobriety test, urine test, breath test, blood test, any kind of test. And do not answer questions. No questions at all. I appreciate your time. Questions and comments, put them down below. Thank you.